In brief, the $40 an hour rate for compensation was in effect from the early to mid 80s all the way through to 2020. And in 2010, Dean Strang and others petitioned the state Supreme Court to raise it to 70, and the court refused. And about 8 years later, John and I filed a similar petition, and we commissioned a study of the SPD that was published and is available. And we tried to convince the court to declare the $40 hour rate unreasonable and to raise the rate for court appointments from 70 to 100. They agreed to do the latter, not the former. And so when the rate eventually ticked up to 70, which I don't want to get into a discussion as to who has the credit or the blame for that number, but anyway, the rate ticked up to 70 in 2020, and we predicted that it would not do much to solve the problem, and as much as the Supreme Court had just declared the $70 an hour rate inadequate. And there are some other structural issues with regard to the SPD, but that's the $40 an hour picture. We waited. We were on and off we were thinking about filing a lawsuit all along after we didn't get any relief in the Supreme Court. And we decided we needed to wait a while to see how the 70 played out. And it's turned out, from everything we know, and I see Tom, you're on Tom is on the call. He can fill in some history, I'm assuming, from Milwaukee better than I can. But anyway, it has not done that. And we don't think that the legislature is going to do something unless they get highly motivated, and this lawsuit's designed to do that.
Yeah, I would just add a few things. I think it's important to understand that this was, first of all, Wisconsin's not the only place this is going on. There are active lawsuits right now in Idaho and Missouri. Missouri just had their class certified. Oregon, excuse me. Yeah, there was one in Idaho, and historically there have been all over the country. And some of our team, specifically this guy out of NYU Law School who used to be with the ACLU, the national ACLU, had been doing these suits for years. And it's a curious dynamic in this sense that public defender systems across the country are underfunded just across the board. And that like starvation funding seems to be rather purposeful among legislatures, including in Wisconsin. And what's curious is when one of these lawsuits is brought, it's fought tooth and nail. In fact, in New York State, in the Hurl Herring litigation, they made 2 trips to their top court, 6 years of wrangling, and they settled the day before trial. So what explains that? Well, it's the political distaste for funding anything that has to do with the criminal legal system, or maybe more appropriately called the criminal punishment system. And so we're running into the same thing here. So we only sued the public defender's office. This has nothing to do with the fact that it's good that we have a public defender system in Wisconsin. That's a good thing. But it's not the public defender that's the goal of this. It's the legislature. They're the ones, it's the state of Wisconsin that has the responsibility under Gideon. And the public defender board and the public defender system itself, the statutory scheme, is just the mechanism that Wisconsin has chosen to meet that obligation. And they do so pretty grudgingly, as you can tell by the funding. By the funding not only for the public defender trial offices and the staff, but certainly for the assigned counsel division, which handles, by the way, 40% of the SPD caseload. And that's, many, many, many tens of thousands of cases. And, and just to give an example of the funding, or the refusal to properly fund, the assigned counsel division portion of the SPD budget is every year, every biennium is purposely underfunded. And they do about 2/3 of it, which means that like January, February of the second year of the biennium, the SPD has to come back for emergency funding. And this has been going on for God knows how long. And then the attorneys don't get paid, and I assume that's just going to be the case going forward. So I guess the long and short of it is that we've got a problem with this attitude towards funding this obligation, which, by the way, the criminal legal system is one of the fundamental things in our democracy. So it's kind of baffling that this is not taken more seriously by people in Madison. And it's both parties too. Nobody wants their name attached to a big number of funding for public defenders or for anything that's going to really help the poor, frankly. They want it attached to more law enforcement, they want it attached to more prosecutors. But even that's not happening if you talk to prosecutors around the state. Talk to John Chisholm about his inability to keep people because of the pay progression. So and just to summarize that, they just don't care about our clients and about poor folks and people of color who are charged with crimes. They don't have any power. They don't have any constituency. They're not going to go to fundraisers. They're not going to help this, that, or the other politician get elected. And so they're just sort of like invisible, and they're pawns. You saw it in this last election where Tim Michaels is running around talking about how tough on crime he's going to be. It's just an old mantra. Tommy used to do that all the time. Every governor is going to mention it, but that's partly the media is to blame for that attitude. So this lawsuit is not aimed at destroying the public defender system. Quite the opposite. This lawsuit is aimed at bolstering it, fixing it, restructuring it, and properly funding it, and probably a long-term effort, hopefully, to have some sort of balance in the system. Because when you stock up the prosecution side and the law enforcement side, all that's going to come through the pipeline, and it's going to have to be handled by Tom's office and every other office in the state. And if you don't give them the resources to do it, to handle it, then you're going to have what we have now, which is kind of a meltdown.
I just have I'm sorry.
Well, I'm just, we don't have specific numbers for every single county in the state, but all the ones that we've looked into, there are cumulatively several thousand, an unknown number, I'm going to ballpark it 3 to 5 or something, of people sitting around that they can't find lawyers for, most of them are in custody. And so this whole system is just basically breaking down, or has broken down. And frankly, the Supreme Court had an opportunity in 2010 with Dean Strang's petition, in 2018 with our petition, and this year in the Lee decision, the Nia Lee decision, to do something more than just scold the legislature and say, you guys really should do more because we have a constitutional crisis coming. It's coming, it's coming, it's coming. Well, guess what? It's here. Whether anybody wants to admit it or not. And so I don't think, obviously the legislature is not listening to them. Maybe they'll listen to this lawsuit. I don't know.
Just a couple of things. I know we often are asked why we're not in federal court, and that's because of the abstention doctrine. which is a federal rule of criminal procedure that basically says the federal courts will not mess with state court criminal justice issues, except in very rare circumstances, they'll abstain. And our research led us to think that we could not survive that issue if the case were brought in federal court. It's in Brown County, in part because Brown County has one of the worst situations in the state. But I also want to stress that this is not, as was widely talked about pre-pandemic, just an up north problem. The shortages that we're seeing around the state are acute and chronic, and range from the southwest part of the state to the northeast, and include Milwaukee. Again, if Tom cares to add any meat to that observation, I'd be more than welcome to hear what he has to say. And the other thing is, what John says is true. The legislature ultimately has the responsibility, as does the governor, to act. In looking who we have to sue, we concluded that the State Public Defender Board are the folks that the state of Wisconsin has held out as those responsible for implementing the state's Sixth Amendment obligations. The legislature is generally immune. Governor has arguable immunity when they've already raised that issue. But regardless, we believe this is the way it has to be pled. We have sued the Public Defender Board not in their personal capacities, but only in their capacities as board members. So this isn't personal. It's what we have to do to get where we need to be. And as John pointed out, everything else has been tried and nothing works. I know the SPD is proposing a rate increase in their budget to $125 an hour across the board. If I'm not mistaken, I don't think it differentiates based on cases or attorney's experience. And that's good to see. Historically, the SPD, this is part of the biennial budget. That budget process usually results in the SPD having the private bar increases cut. It's one of the first things that gets cut before it goes to the legislature. I don't know if that's going to happen this year. I expect there'll be more traction, and hopefully in part because of the problems around the state and the people echoing what we're saying and our lawsuit. I don't know if that would singularly solve the problem. I don't think that the private bar has had the kind of representation it deserves in the public defender budget process over the decades. You're talking about 40% of the cases and 20% or so of the budget. So that's one of the things that we would like to see changed as well, is that there be a voice for the private bar side of the budget process in the biennial budget making.
John or Hank, can you discuss for the lawsuit, what is your request for relief? Like, what are you specifically asking the court to do? To order the legislature to do something, or to raise the money to a higher rate, or what exactly do you want the court to do?
The first thing we're asking is that we get class certification. We have to show numerosity and commonality of interest around the state. Next thing is we are going to ask that the court declare that a person who is SPD eligible have that lawyer appointed within 14 days of their initial appearance. And if the appointment isn't made, the case would be dismissed with prejudice. As a practical matter, we don't expect a lot of judges to flat out dismiss cases, particularly if it has to be with prejudice. We expect that if the legislature hasn't acted to correct things, then we will see courts appointing more at county expense, which was what our state Supreme Court said in 2018. When our petition failed to get them to say 40 was unreasonable, they did say that the circuit court should appoint when the SPD can't find a lawyer. That has not been a widely embraced remedy around the state. The courts don't want to do it because it comes out of the county budget.
Yeah, in fact, many counties, I don't know how many, but quite a few, around the state, the judges have gotten together and said, we're not doing it. If you're SPD eligible, we're not appointing. Now, that's not the case in Milwaukee, luckily. And I think in Brown, they're starting to do it more and more, but it's the case in a lot of counties. And I'm sure that, you know, that if you're in the system, you've seen these Nia hearings, which is in reaction to that appellate case out of Marathon, where they have to show cause to extend the time limits to conduct preliminary hearings. Well, you know, it's turned into kind of a joke, and they just keep doing it. So some, you know, they just come back every 3 weeks, and they just, you know, check the box and say, yep, good cause, can't find a lawyer. Well, we're trying to say, okay, that's enough. You know, this is ridiculous. We thought a lot about our prayer for relief, and like, you know, Hank and I, we don't do, you know, civil stuff, and so we're like, well, let's tell them to like increase the budget and restructure and do this and give all these specific suggestions. And we soon discovered, after talking to some of the folks that are really experienced doing these types of suits, that that's not the way to go in this context, because there's already a mandate that this has to be done. Gideon is the mandate, and it says, states, you're responsible for doing this. And so we wanted to have a prayer for relief that was going to get people's attention. By people, I mean people in Madison. And we thought, well, dismissing a bunch of criminal cases with prejudice, that'll get their attention. And then how to restructure it? Well, then that's going to be the negotiation, you know. Massachusetts has a similar provision where I believe it's 2 weeks. I don't know, Hank, correct me if I'm wrong, but that if you don't get counsel in 2 weeks, it's dismissed.
Well, there's also a 14-day, there's a case from, I think, the 60s, pre-SPD, obviously, that talks about 14 days being a reasonable time for the circuit court to appoint, back when they did all the appointments. You know, I've been around long enough. I used to work for a couple of circuit court judges, and I was in law school, and that's when pre-SPD, when we were doing those appointments, and we can go into all that history as to why that was a bad idea. And we're not, as John said, we're not trying to get rid of the SPD or anything close to it. We you know, we don't want to go back to that pre-1978 time period. There were a lot of problems with judges making the appointments. But if that's the only available remedy in the near term, then I think you have to look at it.
The other problem I think that bears mentioning is that the pool of attorneys willing to take these cases is dwindled dramatically. I don't know what it's at now, maybe Tom knows. But I know that, you know, like back in the day when I used to take these cases, and I took tons of them for a long time, there was like, you know, in the early 2000s, there was like 1,200 attorneys on the certification list. And I think there was like 300-ish that were actively like taking tons of them. I don't know what the numbers are now. I just know that, you know, they are in short supply, and it seems like there's a lack of interest among young lawyers to do this kind of work, which is troublesome. And the other problem is that a lot of current cases, like a lot of modern criminal cases, are a lot more time intensive now, because we have a lot more scientific evidence, and we have body cams, which are great, but, you know, they're very time intensive also.
All right, we'll open it up for questions. Peter Goldberg, you have one in the chat. Do you want to ask it directly?
Sure. Yeah, sorry. Well, I actually have two questions. What are the reasons, besides time intensiveness, the cost and the overhead, that there's no interest in taking these cases because raising the rate wouldn't solve problems such as a total lack of interest or felt lack of qualification.
Well,
And with that regard, are there places where we now have a voluntary urging that one as part of the bar rules that we do pro bono work? Are there any places where this type of work is required? I know that the very few times in my recollection that the really big firms like Foley and Lardner took cases, because they had staff that could work them to death, they did sensational jobs. And I'm just wondering if it becomes mandatory to do pro bono work such as this. That might not solve the problem. Why shouldn't the big boys have to put some of their resources into this type of thing?
yeah, that's a tough question. I know that there's, well, first to take the lack of interest. I don't know, it escapes me because I find it endlessly interesting. I always have, which is why I do it and have been doing it for so long. But when I was younger, starting out, almost all young lawyers took these cases, at least for a while. You know, maybe they drifted off and, you know, went to another area of law, but at least for a few years, it was always the case. And it just appears like that even before the pandemic, that was really just drying up, that people just didn't want to do it. And maybe it was just the money, and maybe it was the intensity. I don't know. So how to generate that interest, I don't know. I try and keep my eye out for young lawyers and, you know, encourage them to keep doing this kind of work. But, you know, it's a big ask in a lot of ways. And as far as the mandatory stuff goes, I know I had this conversation with Adam Giral up in Ozaukee County, and he thinks that's the way to go. He thinks we should just Shanghai people, and he sent me a Ninth Circuit case that says it's perfectly constitutional, and I didn't really get a chance to analyze it that closely, but I think if and I don't know if that's something that the state Supreme Court can just impose or the legislature can. And if that's the case, boy, I'll tell you, I think that, you know, maybe that would be the trigger. Maybe that would be the thing where, in fact, I talked to Jason Russell in Kenosha. He's the chief judge down there. And he's like, I have a solution. I'm going to appoint Frank Gimbel to every single tough case that I have. And then he's going to immediately drive to Madison and get shit done, you know? And I said, well, I don't know, that might work, might not. So I don't know, maybe that is a solution. But it seems like politicians really, they don't listen to much anybody unless there's a big dollar sign, you know, getting deposited into their bank accounts.
Peter, I don't know how things sit at this precise moment, but when we had our petition before the Supreme Court, Ben Kempinen was one of our clients of a sort. He was one of the co-petitioners and a variety of other people, including Frank. Anyway, Ben told me that his law school classes were half the size of what they had been 8-9 years previous. And the whole law school was that. It wasn't just him that they were boycotting or something. And he said that's because, you know, you get standards the same, even though the law school applicants went way down during the Great Recession. I don't think it's really recovered. Maybe it's getting there, but I think there's been in the last decade fewer lawyers coming, at least out of the Wisconsin schools, to replace those who are retiring. That's a piece of it, but it's not the only thing. You know, obviously the rate is a big deal. I think the low rate for all these years has sort of stigmatized the work. And it's stigmatized it in a way that, you know, we shouldn't be afraid of that stigma. But I think for a lot of lawyers looking at taking cases who have a more varied practice, particularly in the smaller parts of the state, You know, this is just something I can relate anecdotally. The last few years of my practice where I was a solo, I get a fair number of calls to take sex cases, private retainer sex cases, because the law firms that were getting the initial referrals didn't want their firm associated with them. I gladly took them. I got a lot of referrals because I wasn't going to compete with those firms on any other basis. But that kind of thing happens, not just with sex cases, but I think with others, it does make a difference. So we've unfairly over the decades stigmatized SPD work as kind of, I remember Sharon Rose from Green Bay ran for the state Supreme Court probably 20 years ago. I don't know how many of you know who she is, but when she was running, she characterized anybody, staff or private, who would take public defender cases as a bottom feeder. Yeah. And I think that kind of thinking has permeated, unspoken perhaps, but it's permeated a lot of the law practice, and it's real. So, you know, there has to be more focus on the folks that are taking private bar cases and how they're viewed and how they're treated. And that's really the issue for the Supreme Court, I think, more than anything. We just have let things slide to a terrible place.
Has the bar sounded in? They're responsible too, it seems to me, to rally their members.
Well, they were supportive of our petition, although the bar president at the time, Paul Swanson, who was a classmate of mine, wouldn't sign on. And even when we filed the lawsuit, I noticed the other day, maybe it's changed, I don't think it has, there's no mention of our lawsuit at the State Bar website. It's like it doesn't count. So I think that they're afraid to weigh in. I can tell you that the other UW professors that John and I know that we talked to about helping back in 18 and even afterwards, they're told if you help, you cannot make it known that you have an affiliation with the UW. That, you know, they're concerned about the budget process, and if they come out for the SPD, that it'll hurt the UW Law School. So there's all kinds of stuff at play in the background that it's hard to quantify, but we know it's there.
Nick, do you want to ask your question directly?
Sure. Yeah, I got a comment first that the Access to Justice Commission has a program, the Pro Bono Honor Roll. If you do 50 hours worth or more, you can self-report that and they put you on the list. And many people don't realize that includes SPD work that you are actually getting paid for, but they consider it pro bono, probably because the amount of money is so small. I think the court reporters too, you know, they're the ones that are getting a problem out of this. I would like the case number so I could look it up. I heard it was Brown County, so if anybody has that, or you could put it in the chat. Yeah, the mandatory thing, I'm really concerned with that. I mean, wouldn't be a problem for me, but you're gonna take a transactional lawyer and make them do criminal law, malpractice problems, legal malpractice lawsuits. They're a real possibility. I was just reading one out of federal district court last week where a lawyer took on a case pro bono, criminal defense, and now he's being sued by his client, legal malpractice action, and the federal court couldn't dismiss it. So maybe those are just iterations.
Yeah,
I'm totally with you guys. This 3,000 to 5,000 number, that's shocking to me. How is this possible? Why is nothing being done?
I think it's higher than that, but again, as John said,
that is even more shocking.
We don't have all the final numbers, but we think it's higher.
So Nick, this just goes to show you the desperation of the situation we're in right now. There's several efforts, at least in Milwaukee County, two that I've seen. One with the Milwaukee Bar Association, trying to recruit, civil lawyers from big firms to come in and actually take cases. And then this other effort, which I think Tom's involved in, that they're just trying to train people just to do prelims, just so they can move cases along. And obviously that's not sustainable, you know? And to your point, Nick, and to, you know, sort of loops around to what I said before, is cases are complicated, you know, especially when you get into, you know, all this stuff coming in from the crime lab and phone dumps, and you know, it's a lot. And if you don't have the antennas built up over years of doing this stuff, you're just not going to cut it. And you might be a warm body, and you might even be a great lawyer, but it's like the Chronic case, if you remember that. It's an ineffective assistance case where a tax lawyer took over and did and he was a great lawyer, but he took a criminal appointment, and obviously he just botched it up and made it all the way to the Supreme Court. They said, well, you know, that's functionally like not having a lawyer. So
Yeah, you know, the whole idea of having non-criminal practitioners or people that have a, yeah, I guess that's a fair term, take cases either in part or in whole is really a bad one. And whether they're conscripted or they volunteer or they're otherwise involved, it's not a good idea. And you don't want a podiatrist doing thoracic surgery, right? It isn't much different. There's been talk about immunity. I think there is some limited immunity if you take pro bono work through the state bar. There's some, or else they cover the malpractice. But even then, if there was immunity from being sued, I think that's a horrible idea, because you're not accountable to your client. If you take CJA cases, you know, and Craig knows this better than anything, you can't take a CJA case unless you file proof of your malpractice coverage every year. And that's a good thing. You know, the SPD should have a similar rule, although right now, if they did that rule, they'd probably lose even more lawyers. That's there's just some other things like that that we think could be helpful to the clients. This is about the clients. You know, we're not looking for any money for us, all the lawyers involved in this case, or the clients. We're looking for injunctive relief. We want the problem to be fixed, and we don't want a Band-Aid. There've been Band-Aids. I predict that there'll be some kind of Band-Aid come out of the budget process by next summer. But it's going to be a Band-Aid. It's not going to have any long-term ability to solve the problem. There needs to be some indexing. There needs to be a real deep dive into a lot of the issues that govern quality. The SPD does a great job in most cases. The staff attorneys, this is not at all an attack on the staff attorneys. You know, I was one for a long time. Peter was one. Tom's one. I mean, Greg. I mean, so we're not claiming there's a failure there. There is almost an impossible job, though, to oversee the quality of the private bar. The director of the private bar for the SPD simply can't oversee over 1,000 lawyers spread all over the state. You know, years ago when I was a new first assistant, we didn't have a private bar division. It was the first assistant's job to investigate and deal with, you know, lawyers that were not doing a good job. And you know, I had to talk a few into withdrawing, or we try to decertify them. Those weren't pleasant talks. But anyway, but the point is, that's also a piece that's missing. This is what we're talking about. What is the client getting from the private bar at the point of delivery? And there's a lot of things that go into that are systemically wrong. How many of them can get fixed in our lawsuit? We don't know. Courts are generally reluctant to micromanage criminal justice systems. Our lawsuit's designed to give the court a lot of leeway, and the state as well, to get a fix.
Well, the bigger picture here is, all right, we're not just fixing or restructuring the public defender's office, we're not just giving them more money. We got to have a serious talk about the lingering effects of the Tommy Thompson administration and the quadrupling of our prison population, and the massive influx of funds for law enforcement, and both at the state and federal level, and really the concentration of that in communities of color. Half of our prison admissions come from 3 zip codes on the north side of Milwaukee. So, you know, that's the image that you know, people like Tim Michaels and others play on without giving it a thought. Yeah, let's build a new prison. Yeah, let's, you know, let's make revocation mandatory on all sorts of things. Let's, you know, and they don't give a really much thought or care about having those folks represented in any meaningful way.
Well,
and-
you're also talking about one. I mean, if you look at the fundamental problem, there are more cases than there are lawyers to take. And that's not enough, but that's what the problem is. One way to decrease that gap is to decriminalize stuff. I mean, we're still in an environment where DAs will charge crap misdemeanors, you know, multiple bail jumpings or paraphernalia or junk to drive up their numbers because the DAs compete with other counties for the assistant DA positions. And they have, I think most of you probably know this, they have a formula. And I don't know how many different counties I've had the DA tell me, well, we're the most needy in the whole state. I mean, I've had him tell me that in consecutive weeks over the years. So I'm not quite sure how it works, but nonetheless, it is certainly possible to drive up numbers at the expense of the SPD, at the expense of society, just so that DAs can compete. That has to change too, if we want long-term fix here.
yeah,
It makes no sense.
along those lines, for example, I have a client in Walworth County, senior at UW Whitewater, dealt 3.6 grams of weed to a CI twice. And they charged him with felony. They want him to have a felony conviction. They want him to do some jail. No record, obviously. I mean, it's ridiculous. It's ridiculous. Oregon decriminalized all drugs, all of them. You know, and that's the same approach that Portugal takes. And so, you know, that's got to be part of the conversation is, and to stop this culture of literally like criminalizing everything and slicing and dicing it into mandatory minimums and more enhancers and all of this nonsense to just increase the ability to allow prosecutors to get convictions, you know, and maybe someday we'll actually have a trial system now, or right now we have a plea system. You know, in the 60s, 70s, about 35% of cases went to trial. Now it's about 3%. So, so those precious constitutional amendments that consume a good chunk of our Bill of Rights that deal with this system, you know, some of them just seem to be dead letters.
Peter just asked an interesting question about, I'll just broadly characterize it as better support staff, more compensation for the private bar to use support staff. Is that?
Yeah.
Okay, well, the way, and then again, I invite Tom to say if I've got this wrong, because it's been over a decade since I was with the SPD, but whatever, now that's considered overhead the same as rent or photocopy paper. And the current system for reimbursing private bar does not allow for that sort of compensation. If you have a particular, like a sentencing issue, and when I hire a sentencing specialist, you can ask for expert money. But for the most part, that isn't allowed, and that's something else that could be changed. And also, I want to add, you know, if part of the solution in certain parts of the states, part of the solution may be to add more SPD staff. And again, but that again brings up the issue, can they add them? Can they add quality staff at the current rate of compensation for staff? You know, we're not trying to mandate a particular Birdsall Schultz patented solution. We recognize there's got to be give and take in all kinds of areas here. So it's not just about the rate. All these things that we're talking about play a role.
I just want to mention that Jesse Long has a comment in the chat about that pay rate that we talked about for the effect on young attorneys. So Jesse, I don't know if you want to elaborate on that, but then I want to go to Colleen. She had a question in the chat too.
Okay.
Sure. I think that it's maybe an oversimplification to say that a lot of young folks aren't interested in public defender work. Law school's expensive and it's just getting more expensive every year. And there's a lot of uncertainty around public student loan forgiveness. And for a lot of folks, you graduate with that degree and you've got $200,000 worth of student loans. It's just not an option. And, you know, they might be interested, it might be what their heart is in, but you have to take care of yourself first and foremost. So like really addressing something with student loans, either really bolstering public student loan forgiveness or increasing the pay, or really like any sort of solution to help the young grads with their public student or with their student loans, I think would go a long way.
I have a theory about universities in the United States, and I believe that they are all secretly run by Tony Soprano, because that's the only really way to justify these massive increases in tuition. They're just, you're absolutely right, Jesse. I mean, so maybe that's, I don't know how to address that, but you saw the blowback Biden got about just what he did as far as the loan forgiveness that he announced, which might not even go through because it's being challenged, and it's a legitimate challenge, the basis that he used. So I don't know. But Jesse, would you say that, I mean, I don't know when you graduated, but would you say that like almost none of your classmates ended up doing this type of work?
I'd say probably out of my entire class, I know maybe 10 people that are in, like, I'm at Legal Action. I know maybe a couple of people who are in like different city attorney offices, but almost everybody went into private practice.
Like civil sort of stuff. Yeah.
And some people went, I think, into big firms doing criminal work, and then like prosecutors, but I know maybe one or two people that went into public defender work.
Colleen, go ahead. You want to ask her?
Sorry, yeah, sure. So I was just asking, I feel like it's very unlikely and unrealistic that the judges would just dismiss cases with prejudice if somebody's not appointed. I think the obvious, in my head, reaction from the bench would be to issue monetary fines for not having lawyers appointed in a timely manner. Because SPD is named as the person what the lawsuit's about, I would assume that fine would go to SPD. In my long-term thought of that, I don't think it really solves much of the problem, and in fact has the possibility of bankrupting the SPD, and then we don't have a public defender agency in the state.
Colleen, we're not trying to punish the SPD. We're trying to get it fixed, okay? And so I don't think that'll really be, I don't think that's going to happen.
You actually think that judges will dismiss cases with prejudice if lawyers aren't appointed in 2 weeks?
I don't think it'll happen very often. No, as I said at the outset, I think that the judges will be motivated in a way they aren't currently motivated to appoint at county expense, and that'll create a ton of additional pressure on the legislature, because they're going to hear from the counties association that they can't afford to do this. You're going to hear, and that's going to, every state rep around the state's going to hear about that, because the county boards and the counties association are going to put pressure. When John and I did the 2018 petition, we got the court to rule, I think it was in July of 18, that the rate would go from 70, the court appointed rate would go from 70 to 100 within a month. The next day, the counties association filed a letter with the court objecting to that and asked for a delay. They got it. It pushed it back almost a year and a half, from the summer of 18 to January of 2020. So they are a very effective and powerful organization on all kinds of issues, not just criminal justice issues around the state. So yeah, I mean, we don't expect a massive amount of people to be walking out the door, cases dismissed, goodbye, forever. please don't come back. No, we don't expect that. But this is one way. It comes down to, is the Sixth Amendment being complied with? It's not right now. And finding the SPD doesn't comply with the Sixth Amendment. It doesn't solve the problem.
I could also see an argument about separation of powers, and that's a backdoor way of telling the judicial branch, telling the executive branch to spend money, which, the conservatives on the Supreme Court would have nothing to do with. And in fact, as far as I think during our 2018 hearing, Dan Kelly actually made a comment about, well, I know how you can get some money. You just start dismissing cases, and the legislature will cough up money. It'll make your head spin, something like that. So, yeah, I think this has to be something where there's got to be. Right now, our lawsuit is just like sort of the trigger, but it has to be more of a fundamental, holistic approach. And
Yeah,
I fear that's not going to happen.
well, there's been talk of, well, why don't we just increase staff attorney caseloads and that'll solve a lot of the problem. That is the worst idea of all. And we're not going to do everything we can to prevent that from happening. That is not at all okay. I mean, they're already, the public defender national guidelines for what's an acceptable caseload. And again, Tom would be more up to date than I am, but I understand that they're currently, if not very recently, about to be revised downward, well below where the SPD sits right now. So it's not a solution it's maybe a solution to add staff in some places. It's not a solution to add cases to the existing staff.
I'd like to ask either Tom or Craig if you guys know the numbers that are on the number of attorneys that are on the certification list now.
If you're asking me, I don't know. I don't obviously work at the SPD, so I don't really know. I do have a question though, since I unmuted myself. Are there Nia Lee hearings going on around the state, and are cases being dismissed pursuant to those from time to time?
Yes and no.
Okay.
They're going on, and there's no dismissals.
I've seen a couple. I could, maybe on one hand I could count them, but again, that's not a comprehensive look at just when we're looking at cases we do see occasionally. And I think that what you typically see, and this is again a CCAP entry, is something like, well, court applied Nia Lee standards and found good cause to adjourn.
Right.
It doesn't say how those
that
standards were
happens
actually,
pretty routinely. I mean, I don't know that they really apply the standards, but they do obviously adjourn cases for cause pursuant to that. But so then the other question is, what's the time frame on this? It sounds like the state has answered, and what's next, or what's happening?
they haven't answered.
They haven't.
They filed a motion to dismiss. They've not filed an actual answer to our lawsuit.
Based on immunity grounds, or like sovereign immunity, or what exactly?
That's part of it, but there's a variety of issues. I don't have the pleadings in front of me. I don't want to quote for them from my head, but there's an issue of, whether a circuit court can actually order another circuit court to do something. They've raised that issue, and some immunity issues as well. You're right.
Gotcha.
So to answer your question, I anticipate that, like all civil litigation, especially big civil litigation, this is gonna be a slow burn. This could be years.
Yeah.
But the good news is we have a supremely talented and experienced team with lots of resources. So whatever it takes, it takes.
Yeah, and the guy, and Jason Williamson, who's a part of our team, he's the NYU professor, has successfully recently litigated the very similar case in Missouri and is involved in the recently filed Oregon case. So we have talent, and we have experience, and then we have John and me.
Tom, you've been mentioned a couple times, and I think John asked you a question about numbers on the
Yeah,
private bar.
Yeah, I yielded the floor to my former colleague Craig Johnson, but what I would say about it is I don't know, just sitting here, exactly how many lawyers are on the list. But I do agree with the statement that the number of lawyers who are actively taking the cases has dropped significantly. And I do think that the number of lawyers who are entering the practice is greatly reduced. And we see lots of signs of that. And the long-term health of these issues requires that, people enter into the work, find it really satisfying, really care about it, and out of that kind of commitment, develop the courage and the skills and the experience necessary to move through the representation of clients to those cases, which really require a very high level of skill.
Right.
And I think that the pipeline, as it were, is not what it could be. And, we see that, the effects of that.
Tom, I think I read, I'm stretching here a little, but I think I read that your total statewide supply of lawyers is down about a third from whatever its peak was. Does that seem about right? And I don't want to be quoted on that because I'm not sure, but I think I saw Kelly or somebody say that not too long ago.
Yeah, I don't, as a practical matter in terms of numbers, I don't have those, but
Yeah.
there's been a significant drop, no question.
Okay.
And there have been experienced lawyers who have retired, from the practice, I think during the pandemic, who might, had the pandemic not occurred, might have stayed longer and continued to take cases. So that attrition was accelerated. And I guess it's probably fair to also say that we're not the only enterprise where there are workforce disruption issues. I think a lot of disruption in the workplace is occurring, and we're feeling the effect of that.
The only thing I would respond is that the core problem existed, before the pandemic.
Mhm.
I'm not saying it wasn't exacerbated, but to suggest that it's a pandemic, without the pandemic, we wouldn't be sitting here. I don't think that that's accurate.
Yeah, I'm not suggesting that. I'm
Okay.
saying I think it can get worse.
This is,
Yes, yeah, I agree.
this is a somewhat tangential question, but because it doesn't have to do with progressing the cases necessarily, but what's the circumstance with appropriately detained people? That is, are they honoring the constitutional requirement that bail only be set if it's necessary to assure the appearance of an individual? Or are they still salting away people who really ought not to be in custody?
Years ago, I did a presentation to the Supreme Court and Court of Appeals, and it's a long story as to why I did it. But anyway, at the end, there was a discussion, and we were talking about bail, and I made the comment that well, we all know it's cash bail as soon as we see the TV camera, and that pissed off those judges and justices. I remember that discussion, but that's a factor. I mean, anything that could come back and bite a judge in the ass is going to be a bail factor. You know that, Peter. That hasn't changed. I mean, if you're going to be on TV, if you're going to be in a newspaper, if it's a drunk driving, you're worried the guy's going to get in another drunk driving. You don't want your election's coming up next year. You don't want to go there if you're a judge. It hasn't really, to me, in my decades of doing it, it seems it's kind of the same thing. We're still locking people up based on judicial fear.
Habeas corpus lies.
Well, not to lose all hope here. I mean, look what happened in just the last election, and Tony Evers is still here, even though he's our defendant. Thank God he got elected, because his stated goal of reducing the prison population in half. I mean, that's a brave stand to take in this sort of environment. And Josh Call, certainly would have, even though he's fighting our lawsuit tooth and nail, he's certainly a better option than his opponent would have been. So, there's there's this pendulum about this view on crime. And, you know, I don't know, maybe it's swinging in our direction. Maybe it's not going to be enough. I don't know. But I guess, you know, when you're a criminal defense lawyer, you get used to getting kicked in the teeth a lot. And you just pick them up off the ground, you glue them back in, and you just go back and do it again. So we'll just keep coming at them, and we'll hopefully we've already been reaching out to some conservative Republican types in the legislature to try and start the conversations about, you know, what really needs to be done here. And I think there's a lot of attraction to them. I think they see a lot of libertarian principles in what we're talking about here. So despite the, you know, the seemingly intractable pro-crime culture, you know, I think there's some room to move there, and certainly we'll try.
All right, with that, we're right at 1 o'clock. So I want to thank John and Hank for joining us today. And we really appreciate their time coming and talking with us, and good luck in the lawsuit. And for those who are interested in seeing the complaint, John actually put a copy of it in the chat. So if you want to, before you log off, download that PDF to see the actual pleadings, and then you'll have the case number.